Every single justice on the Supreme Court, all 9 of them, just agreed on something that changes exactly how much evidence police need before they can enter your home without a warrant during what they believe is a mental health emergency. If you've ever wondered what actually happens legally when someone calls police because they're worried about a family member in crisis, this ruling is the answer. And it resolves a question that federal and state courts had been answering in completely different ways for years, leaving your actual constitutional protection dependent on which state you happen to live in. On January 14, 2026, the Supreme Court issued a unanimous decision in Case v. Montana, and while the vote was 9-0, the opinion itself and the 2 separate concurrences written alongside it reveal a decision that's far more layered than a simple headline about unanimity suggests. This is also the first major Fourth Amendment case the court has taken up in years, according to legal scholars who follow the docket closely, meaning the justices had gone an unusually long stretch without directly addressing core search and seizure questions before this case finally forced their hand. I'm going to walk you through exactly what happened to the man at the center of this case, what standard the court actually adopted, why it took 9 justices agreeing on the outcome but writing 3 separate opinions to explain it, and what this means the next time police show up at a door believing someone inside needs help. Before we get into the case itself, if you want legal breakdowns like this, the moment a ruling actually clarifies your rights, not weeks later after the story's already been flattened into a slogan, subscribe and turn on notifications right now. This is exactly the kind of decision that quietly reshapes how police interact with the public in one of the most common and highest stakes situations imaginable. And almost nobody outside the legal community actually understood what it did. Cases like this one rarely trend the way a flashy gun rights or free speech ruling does, but they affect vastly more people in practice, because welfare checks and mental health crisis calls happen constantly, in every community, in ways that a case about a rare constitutional dispute never will. Let's get into exactly what happened. Here are the facts, and they matter enormously to understanding why this case reached the Supreme Court at all. On September 27, 2021, in the small town of Anaconda, Montana, William Trevor Case, an Army veteran with a documented history of mental health struggles and prior suicidal behavior, called his ex-girlfriend and threatened to kill himself. During the call, she heard what sounded like a gun being cocked, then a sound like a gunshot, followed by silence. She called 911. Local police officers, who already knew Case personally and were aware of his mental health history and past confrontational encounters with law enforcement, responded to his home. They knocked on the door and shouted through an open window, but got no response. Looking inside, they could see an empty handgun holster and a notepad with writing on it that looked like a suicide note. Believing Case might be seriously injured or at imminent risk, the officers made the decision to enter the home without a warrant to check on him and render emergency aid if needed. Once inside, as officers approached a bedroom closet where Case was hiding, he threw open the closet curtain while holding an object that looked like a gun. An officer, believing he was about to be shot, fired and injured Case. A handgun was later found near where he had been standing. Case survived, was taken to the hospital, and was subsequently charged with and convicted of assaulting a police officer. He moved to suppress the evidence from the search, arguing the warrantless entry into his home violated the Fourth Amendment, and that argument, working its way up through the Montana courts and eventually to the U.S. Supreme Court, became the entire basis for this case. The first segment of this story is the legal question the case was actually built to answer because it's more specific and more technical than the tragic facts alone suggest. Back in 2006, in a case called Brigham City v. Stewart, the Supreme Court had already established that police can enter a home without a warrant if they have what the court called an objectively reasonable basis for believing that someone inside is seriously injured or in imminent danger of injury. That much was settled law well before Case ever reached the court. What remained genuinely unresolved and what different federal appeals courts and state Supreme Courts had answered in conflicting ways for years was exactly how demanding that objectively reasonable basis standard actually is. Does it require the same level of proof as probable cause, the standard normally required before police can search a home in a criminal investigation? Or does it allow for something below that threshold, a lower bar sometimes described as reasonable suspicion, precisely because emergency aid situations involve protecting life rather than gathering evidence of a crime? Case's attorneys argued forcefully for the higher standard. pointing to the court's own 2021 decision in Caniglia v. Strom, where the justices had unanimously rejected a broad, open-ended community caretaking exception that would have let police enter homes based on a vague, general sense that they were helping rather than investigating. Case's lawyers argued that if Caniglia meant anything, it meant courts should be skeptical of loose, easily satisfied justifications for warrantless home entry, and that consistency demanded requiring full probable cause here too. It's worth understanding the broader precedent chain here because Brigham City wasn't the only prior case shaping this dispute. 3 years after Brigham City, in a 2009 case called Michigan v. Fisher, the court applied that same objectively reasonable basis standard to a situation where officers found broken windows, blood on a door, and a man inside screaming and throwing things, again upholding a warrantless entry without requiring anything approaching the full probable cause standard used in criminal investigations. Case's legal team argued that Fisher and Brigham City both involved much more dramatic, visually unmistakable evidence of an ongoing violent emergency, blood, broken glass, an active physical altercation visible from outside, compared to the more ambiguous second-hand information officers had in his own situation, a phone call reporting a sound that could have been a gunshot, relayed through an ex-girlfriend who wasn't present at the scene herself. That distinction between directly observed physical evidence of violence and second-hand reports relayed through a third party became a central part of the argument for why courts should require a more demanding standard before allowing entry based on the kind of indirect, reported information that increasingly characterizes modern 911 calls involving mental health crises. The second segment is what the Supreme Court actually held, and the answer disappointed those hoping for a bright, easily applied rule in either direction. But before getting to the court's actual answer, it's worth understanding what Montana argued on the other side because the state's position was rooted directly in the constitutional text itself. Montana's lawyers pointed out that the Fourth Amendment's actual language requires probable cause specifically for the issuance of warrants, not as a freestanding requirement that attaches to every single government intrusion into a home regardless of context. Their argument was that grafting a probable cause requirement onto the emergency aid exception would functionally punish officers for acting cautiously and quickly in situations where lives might genuinely be at stake, forcing them to either delay potentially life-saving intervention while gathering more evidence to satisfy a heightened standard, or risk having any evidence discovered during a good-faith emergency response thrown out later because a court decided in hindsight that the information available in the moment didn't quite rise to full probable cause. Montana argued that the entire purpose of the emergency aid exception is to allow officers to act on real-time, incomplete information during fast-moving, high-stakes situations, and that importing the same evidentiary rigor used for criminal investigations, where the government typically has time to build a case and go before a judge, would undermine the very emergency response function the exception exists to protect. Justice Elena Kagan, writing for a unanimous court, held that the Brigham City standard, the objectively reasonable basis test first articulated back in 2006, applies without further modification, meaning the court declined to graft a separate, more demanding probable cause requirement onto it. The opinion reasoned that emergency aid entries are fundamentally different in purpose from searches conducted to gather evidence of a crime, and that the entire justification for allowing police to act quickly in a genuine emergency would be undermined if officers first had to satisfy the same rigorous evidentiary threshold normally reserved for criminal investigations, where the government has time to go before a judge and get a warrant precisely because there's no emergency forcing immediate action. Applying that standard to the specific facts here, the court found that the combination of the 911 call describing a possible self-inflicted gunshot, the officer's own prior knowledge of Case's mental health history, the lack of any response at the door, the visible empty holster, and the apparent suicide note together gave the officers an objectively reasonable basis to believe Case was seriously injured or at imminent risk, satisfying the standard and making the warrantless entry lawful. The third segment is why this decision, despite being unanimous on the ultimate outcome, produced two separate concurring opinions because that detail tells you the underlying agreement was narrower than a simple 9-0 vote suggests. Justice Sotomayor wrote separately to emphasize that officers responding to mental health crises should seriously consider de-escalation strategies and less invasive alternatives before deciding that entry is truly necessary, signaling her view that today's ruling should not be read as giving police a blank check to enter homes reflexively anytime a call involves a mention of mental health or self-harm, and that the objectively reasonable basis standard still requires real, case-specific facts, not just a general category of concerning call. Justice Gorsuch also wrote separately, reflecting his own long-standing concerns about how expansively lower courts sometimes apply exceptions to the warrant requirement, and using his concurrence to stress the specific, fact-bound nature of the majority's holding rather than treating it as a broad, general license for warrantless entry whenever officers invoke concern for someone's welfare. Neither concurrence disagreed with the outcome in this specific case. Both were aimed at shaping how lower courts apply this standard going forward, making clear that the objectively reasonable basis test, even without a separate probable cause requirement layered on top, is still a real, meaningful standard that has to be satisfied with specific facts, not just general concern. The fourth segment is how this ruling connects directly back to Caniglia versus Strom, the 2021 case many gun owners and Fourth Amendment advocates already know well, because understanding that connection is exactly what clears up confusion for anyone who's followed this area of law even casually. Caniglia rejected a broad, standalone community caretaking exception, the idea that police could enter homes anytime they were performing some general public safety function unrelated to criminal investigation. Case versus Montana did not revive that broad exception. It confirmed instead that a narrower, more specific doctrine, the emergency aid exception first established in Brigham City back in 2006, remains available and clarified exactly what standard of proof that narrower doctrine requires. Justice Kagan's opinion is careful to distinguish the two situations. Caniglia involved police acting on a vague, generalized sense that removing someone's firearms would be a good idea for everyone's safety, with no specific, immediate, ongoing emergency unfolding in real time. Case involved officers responding to an active, unfolding situation, a caller reporting the sound of a gunshot, no response at the door, and visible physical evidence suggesting an ongoing crisis. That distinction between a general safety judgment call, made after the fact, and an active emergency unfolding in real time, is exactly the line the court has now drawn clearly across two related but legally distinct cases. The fifth segment is what makes this ruling matter nationwide beyond just Montana, because before this decision, the exact same set of facts could have come out differently depending entirely on which federal circuit or which state Supreme Court happened to be reviewing the case. Legal analysts tracking Fourth Amendment litigation had documented a real, meaningful split among federal appeals courts, with some circuits, including the 11th Circuit covering Florida, Georgia, and Alabama, requiring something closer to full probable cause before allowing an emergency aid entry, and other circuits applying a more lenient reasonable suspicion style standard, meaning police officers, prosecutors, and defense attorneys across the country were operating under genuinely different rules depending purely on geography. A person facing an identical set of circumstances, the same phone call, the same visible evidence, the same lack of response at the door, could have had the resulting search upheld in one part of the country and thrown out entirely in another, purely because of which federal circuit's precedent applied. That kind of split is exactly the situation the Supreme Court tends to eventually resolve, because it means the same constitutional right, freedom from unreasonable search and seizure inside your own home, was being enforced with meaningfully different levels of protection in different parts of the country, undermining the basic premise that the Fourth Amendment means the same thing no matter where in the United States you happen to live. Case versus Montana now gives every court in the country, criminal defense attorneys handling suppression motions, and departments training officers on how to handle these calls a single unified national standard to apply going forward, ending years of genuine documented inconsistency in how this exact question got resolved from one jurisdiction to the next. The sixth segment is what this actually means for you practically, whether you're a gun owner thinking about wellness checks, a family member of someone with mental health struggles, or simply someone who wants to understand your rights during a genuine emergency response. Understand that the objectively reasonable basis standard confirmed here is real, but not especially high, meaning officers responding to a call involving specific, concrete indicators, a reported gunshot, visible signs of injury or crisis, no response despite genuine attempts at contact, generally have solid legal footing to enter without a warrant if those specific facts are present. But understand equally that this standard is not a blank check for entering any home connected to any mention of mental health concerns in the abstract. The specific concrete facts still matter enormously, and Justice Sotomayor's concurrence in particular signals that courts reviewing these cases afterward will continue scrutinizing whether the facts actually available to officers in the moment genuinely supported an objectively reasonable belief in an ongoing emergency, rather than accepting a vague, generalized invocation of welfare concerns after the fact. If you or a family member has a documented history that police departments in your area might already be aware of, understanding that this history can factor into how officers assess a future call, exactly as it did in Case's own situation, is worth discussing proactively with family members and, where relevant, with a mental health or legal professional familiar with how these calls tend to unfold in your specific community. Let's step back and name the single thread running through this entire case. A unanimous 9-0 vote can create the impression of total, uncomplicated agreement. But the reality here, 3 separate opinions addressing the same outcome from 3 different angles, shows a court that agreed on where this specific case landed, while still working through real, substantive disagreements about exactly how that standard should be applied and constrained going forward. The core holding is genuinely significant, a single nationwide standard for when police can enter your home during a perceived emergency, resolving years of inconsistent rulings across the country. But the concurrences are just as important for understanding where the real boundaries sit, making clear that this standard requires specific, concrete, case-by-case facts rather than a generalized invocation of concern, and that lower courts are expected to hold officers to that specific standard going forward rather than treating this ruling as a broad, automatic justification for warrantless entry. It's also worth appreciating why this particular fact pattern, involving a genuine, tragic mental health crisis rather than a more typical criminal investigation, made this such a difficult case for the court to resolve cleanly. Nearly every justice across every point on the ideological spectrum has written at some point in recent years about the tension between protecting individual privacy in the home, one of the most deeply rooted values in American constitutional law, and giving police enough flexibility to actually save lives in fast-moving emergencies where waiting for a warrant could mean the difference between life and death. Case versus Montana did not eliminate that tension. It drew a specific, workable line through it, one that will now get tested, refined, and litigated in lower courts for years to come, as new fact patterns test exactly how far the objectively reasonable basis standard actually stretches in practice. If there's one thing worth taking from this breakdown, it's that unanimous Supreme Court decisions are not always as simple as the vote count suggests. This case resolved a genuine years-long split among lower courts on a question that affects an enormous number of real, difficult, high-stakes encounters between police and people in crisis, and it did so while leaving real, meaningful guardrails in place through the concurring opinions that came along with the majority ruling. Understanding both the headline holding and the more nuanced boundaries written into the concurrences is the difference between actually knowing what changed on January 14, 2026, and just repeating the flattened, oversimplified version of the story. If this helped you understand a ruling that could genuinely matter to your own family someday, share it with someone who has a loved one dealing with mental health struggles. Subscribe so you catch the next major ruling the moment it clarifies your rights, and I will see you in the next one.